When faced with criminal charges, one of the most crucial decisions you'll make is whether to plead guilty or take your chances in court. This decision is not just a legal one, but also a personal, emotional, and financial one that can affect your future for years to come. In this video, we'll guide you through the most important factors to consider when making this decision. With insights from experienced criminal defense attorneys, we'll help you understand the risks and benefits of both options so you can make an informed choice. Stay tuned until the end to learn how to navigate this life-altering dilemma. Understanding the charges, the first step. Before making any decisions, it's essential to fully understand the charges against you. Criminal cases range from minor offenses to serious felonies, each carrying different legal implications. For instance, a misdemeanor may lead to probation, while a felony could result in years of prison time. Evaluating the specifics of the charges, such as the evidence, the severity of the offense, and any potential defenses, will shape your strategy. If the charges are light and the evidence is weak, pleading guilty might be a quick resolution. On the other hand, more serious charges with strong evidence may push you towards a trial. Understanding the charges sets the stage for your entire defense strategy. The power of legal advice. Consult an expert. One of the most valuable assets you can have when deciding whether to plead guilty or go to trial is the guidance of an experienced criminal defense attorney. Attorneys can assess the case from all angles, providing an objective view of the strengths and weaknesses of the prosecution's evidence. Their expertise allows you to make a fully informed decision, taking into account not only the immediate consequences, but also the long-term impacts of either option. Legal advice helps demystify complex legal procedures, ensuring that you're not making a decision based solely on emotions or fear, but on a strategic understanding of your situation. Evaluating the evidence, strengths and weaknesses. A critical factor in deciding whether to plead guilty or go to trial is the strength of the evidence against you. If the prosecution has overwhelming evidence, such as irrefutable eyewitness testimony, DNA evidence, or a confession, pleading guilty may be the most prudent option to secure a lesser sentence. On the other hand, if the evidence is weak or circumstantial, your chances of winning at trial could be strong. A skilled defense attorney will carefully review all evidence, cross-examine witnesses, and explore potential legal flaws in the prosecution's case. The quality of the evidence often dictates whether you'll face a harsher penalty or a more favorable outcome in court. The risk factor. How much are you willing to gamble? Every legal decision carries an element of risk, and choosing between a guilty plea or a trial is no different. By pleading guilty, you might secure a plea deal with a reduced sentence, which can offer a sense of closure. However, going to trial opens the door to a win, but carries the risk of a much harsher sentence if the jury finds you guilty. Weighing these risks involves considering your personal situation, including how much time, money, and emotional energy you're willing to invest in the case. If you choose trial, there's always the possibility of a not guilty verdict, but it's crucial to understand that the stakes are high and outcomes uncertain. Sentencing outcomes. Pleading versus fighting. When you plead guilty, you may have the option of receiving a more lenient sentence, especially if you cooperate with authorities or take responsibility for your actions. Prosecutors often offer plea deals to avoid the uncertainty of trial, and the agreement can reduce the punishment significantly. In contrast, going to trial means that if you're convicted, the sentencing can be more severe. If the jury finds you guilty of the charges, judges typically have little leeway in deviating from sentencing guidelines. It's important to assess how a guilty plea may lead to a shorter sentence or lighter penalties compared to the possibility of facing a long, uncertain trial. The influence of public opinion. How much does reputation matter? In high-profile cases, the pressure of public opinion can be overwhelming. Public perception, shaped by media coverage and community opinion, can influence both the defendant's decision and the attorney's strategy. A guilty plea, especially when the evidence is clear, might help preserve your reputation or reduce the public's harsh judgment. However, if you go to trial, the outcome can be uncertain and potentially damaging, both legally and socially. In such cases, your attorney can guide you on whether a guilty plea could minimize harm to your personal or professional reputation, especially if you are in the public eye or facing a scandal. The role of negotiation. Can you secure a better deal? Negotiating a plea deal can be one of the most effective ways to avoid trial and secure a more favorable outcome. Criminal defense attorneys are skilled in plea bargaining, where they work with the prosecution to reduce charges, secure a lighter sentence, or eliminate certain penalties. A strong negotiation can result in a deal that significantly lessens your punishment, often without the need for a lengthy and stressful trial. In cases where evidence is stacked against you, negotiating for a plea deal might be the most strategic option to reduce the potential consequences. Understanding this negotiation process is critical in deciding the best path forward. Emotional toll. The psychological costs of trial. The emotional toll of going to trial cannot be underestimated. A trial is not only a legal process, but also an intense psychological ordeal. Preparing for trial, waiting for verdicts, and dealing with the unpredictability of a jury's decision can cause extreme stress and anxiety. Pleading guilty, while not without consequences, may offer a sense of closure and control over your situation. For many individuals, the emotional cost of prolonged legal battles, uncertainty, and fear of a severe sentence is significant. Understanding how you cope with stress, uncertainty, and potential public scrutiny can guide your decision on whether to risk trial or accept a plea. The time factor. Trial versus plea agreement duration. The length of time it takes to resolve your case can be a deciding factor in whether you choose to plead guilty or go to trial. Plea deals can often be resolved quickly, sometimes within weeks, depending on the specifics of the case. In contrast, trials can drag on for months or even years, especially if there are numerous legal motions, delays, or appeals. The decision to plead guilty might offer a faster resolution, which could be appealing if you're facing financial or emotional strain. Additionally, avoiding a prolonged trial may allow you to focus on rebuilding your life or career sooner. The impact on your criminal record. Pleading guilty usually results in a criminal conviction, which will appear on your record and may affect your future in significant ways. However, certain plea deals may allow for reduced charges or even expungement opportunities, depending on the jurisdiction and the nature of the crime. Going to trial and losing may result in a more severe conviction, with no chance of reducing the charges or having them erased in the future. In some cases, trial may result in harsher penalties, including longer prison sentences, mandatory fines, or mandatory rehabilitation. The impact of either decision on your criminal record should be weighed carefully to determine the best long-term approach. Risk of losing your job and family ties. A criminal conviction, whether from pleading guilty or losing a trial, can have serious repercussions on your job, family, and personal life. Certain charges may cause you to lose professional licenses, employment opportunities, or even the ability to travel freely. On the other hand, avoiding trial through a guilty plea may allow you to maintain your employment or minimize damage to family relationships. It's important to consider how each option will impact your job prospects, reputation, and personal relationships in the long run. Your decision should reflect your priorities, balancing legal consequences with your broader life goals. The ultimate decision, trusting your instincts. Ultimately, the decision to plead guilty or go to trial comes down to your instincts, informed by the advice of your attorney and the specific details of your case. While legal strategy and evidence play a significant role, how you feel about the situation, whether you trust the legal process or want to fight for your innocence, is crucial. Your attorney can guide you with expertise, but trusting your gut and weighing personal values, risks, and benefits will lead to the best decision for you. After considering all factors, you should feel confident in your choice, whether it's taking the plea or facing the trial head-on. The decision between pleading guilty or going to trial is never easy, but with the right information and expert advice, you can make the best choice for your situation. Take the time to assess your charges, evaluate the evidence, and consult with a skilled criminal defense attorney. This decision will shape your future, and it's essential to approach it thoughtfully. If you found this video helpful, be sure to like, comment, and share it with others who may benefit. Don't forget to subscribe to Criminal Defense Attorney Tips for more expert advice on navigating the criminal justice system. Stay informed and take control of your future.